Hey y'all, today we are continuing looking at the Aaron Spencer case. It is set to go to trial starting January 26th. That's when they'll start picking a jury and then go from there in Lonoke County, Arkansas. Um, we have documentation to go over that suggests that the police or the prosecutors have lost evidence. And the defense wants there to be something done about the spoliation or loss of this evidence. So we have the defense asking for this, and then we also have the state's reply. I do not have a ruling on it, but what would you do in this case? If you do not know, Aaron Spencer is a case where the father, pictured here, woke up at 1 a.m. in the morning to his daughter, 13-year-old daughter at the time, being missing. His daughter is the victim of a 60-something-year-old man named Michael Fosler, who was being charged with like 43 counts or 46 counts of disgusting, vile things to do with a minor and things like that, I believe found on his computer and so forth. And Aaron Spencer's daughter was the victim of those charges that were pending for him. Fosler was out on bond of $5,000 because you only got to put down 10% of a $50,000 bond. No GPS monitoring, but had a no contact order, a piece of paper that said, hey, don't contact or go near the victim, which is Aaron Spencer's daughter. So that happens in July. Then we get to, I believe, October, and Fosler is now violating his bail conditions and his bond conditions, and he goes and Spencer's daughter gets in the truck with him. To me, it doesn't matter why or how. I don't care that she's 13. This man has obviously been grooming her and doing other things. And she did not have her father or her mother's permission to leave the house, especially with this predator. So Aaron Spencer goes looking for his daughter. He finds his daughter in the truck of the predator, Fosler, on the side or is driving down the road. So Spencer gets them to pull over or get into a ditch, and one way or another, Aaron Spencer ends up shooting Fosler to protect his daughter. Aaron Spencer claims that this is self-defense because his daughter, in his mind, was in imminent danger. After all, she is the only witness against him in his upcoming 43 to 46 charges. So, could he have gone and killed her? Could that have been happening? In Aaron Spencer's mind, that could be what is happening. Is he going to abuse her in the predatory ways that he's done previously, which puts his daughter at harm? And is in the act of kidnapping. So, this father did what most fathers would probably do. But now in this case, because they are charging Aaron Spencer with murder of this, because they say it's vigilante, he says it's self-defense, and this is the same judge and court that also let this predator out on a low bond and just a no contact order. And now they are saying that this predator is actually the victim of Aaron Spencer. And so now there's just missing evidence as they're trying to convict this man for protecting his daughter. So let's jump into this. So here we have filed November 25th, 2025, in the Circuit Court of Lonoke County, Arkansas, First Division, State of Arkansas versus Aaron Spencer. Motion for adverse inference jury instruction and hearing on spoliation/destruction of evidence. The defendant, Aaron Spencer, by and through his attorneys, requests that an adverse inference jury instruction and a hearing on spoliation and destruction of evidence, the loss of the memory card containing recordings made by a dashboard camera in Michael Fosler's vehicle by the Lonoke County Sheriff's Office. So, apparently, in Michael Fosler's truck, there was a dashboard camera, and it had a, a memory card in it and recorded some stuff during all of this. And now that is lost, this memory card that was in that. Is it lost on purpose? Was it destroyed on purpose? Was it just mishandling? Was it an accident that nobody could have foreseen? But in cases that kind of looked corrupt, it's hard to sit here and think that this was done by accident because of what they're trying to do. They also wanted to keep this case hush hush until the Supreme Court said no. This case has to be public. You can't just do things in secrecy because you're embarrassed or you don't like the way it makes you look. Sorry, the public has a right to know what you're doing, in the members of the community need to know what their government is doing because they are supposed to be representing the people, and their actions don't seem to be representing the people in this community, in my opinion. An adverse inference jury instruction is necessary because the government lost a memory card containing video footage of the shooting and the events immediately preceding it, despite knowing that the footage was material to Mr. Spencer's defense. Discovery shows that the Lonoke County Sheriff's Office failed to follow its own procedures for documenting and preserving evidence. Because of these failures by Lonoke County Sheriff's Office, material evidence no longer exists. For this reason, the court should grant the adverse inference instruction. In addition, Mr. Spencer asked for an evidentiary hearing to establish grounds for dismissal of the case under California versus Trombetta and its progeny. Mr. Spencer argues that the charges against him should be dismissed as a result of the state's destruction of evidence in violation of due process clause of the 5th and 14th Amendment of the United States Constitution, Article 2, Section 8 of the Arkansas Constitution, and the principles set forth in Brady v. Maryland. And this was further developed by Arizona v. Youngblood. The destruction of evidence stems from a complete failure by Lonoke County Sheriff's Office to safeguard material evidence related to a death investigation and accompanying arrest. The video footage of moments leading up to the shooting had obvious evidentiary value. The Lonoke County Sheriff's Office acted in bad faith in losing this critical piece of evidence, entitling Spencer to relief under California v. Trombetta and its progeny. Spencer requests an evidentiary hearing to address the loss of destruction of the evidence and to support his claims herein, wherefore the defendant, Aaron Spencer, asks the court to grant his motion and for any other relief the court finds appropriate. And then it was served and written to the proper people. Now, they are asking for an adverse instruction, but then they're also saying, it could be grounds for dismissal and we want a hearing on that. The thing is they're going to do the least dramatic way to try to fix the problem. So if the judge allows this at all, she would probably choose the adverse instruction as opposed to dismissing it. She's not going to dismiss the case. They did a motion for dismissal on other grounds previously that we went over. That motion to dismiss the case was denied. And so I don't see her doing it here. But so this was the motion. Now we're going to look at the brief, which they're very similar, but the brief is a little bit longer. So here's the brief in support of the motion for the adverse inference jury instruction and hearing on spoliation/destruction of the evidence. This was also filed on November 25th, 2025. The defendant, Aaron Spencer, by and through his attorneys, requests for the adverse jury instruction to remedy spoliation and destruction of evidence resulting from the Lonoke County Sheriff's Office loss of memory card containing the dashboard camera recordings from Michael Fosler's vehicle. Spencer also seeks an evidentiary hearing to show this loss violated his constitutional due process rights. This can be considered exculpatory evidence. It could help the defendant prove that it was a justified killing and show things or could possibly hear things off of it. But now it's just not there. And is it not there because it doesn't help the prosecution? Did they just carelessly do things with it? I get that the memory card is small, but it's your job to keep track of evidence and make sure that evidence just doesn't go missing because it looks real convenient. Aaron Spencer intends to argue at trial that he killed 67-year-old Michael Fosler while defending his then 14-year-old daughter. I'm sorry, 14. I said earlier she was 13. I think she was 13 when everything originally started, 14 when this incident happened. Whom Fosler had picked up from her home in the middle of the night. Mr. Spencer's daughter was key witness against Fosler in a pending case involving 43 felony counts. Okay, so I was right with 43. All stemming from Fosler's sexual exploitation of her, including internet stalking, SA, child P. The offenses carried a potential life sentence and would be capital crimes if charged today. So these are the crimes that Fosler was facing. This is the man that Aaron Spencer killed, who was with his 14-year-old daughter, who he had kidnapped and had done these things before to his daughter. Those things I just listed off. Those nasty, vile things. Aaron Spencer thought his daughter could either be killed because she was the only eyewitness, key witness, in getting him charged with those 43 counts. So she was either in fear for her life that she may not come back alive, or his daughter was going to have to suffer these vile things again from this person. And yet, Fosler was free on bail on the night of October 8th, 2024, when Mr. Spencer discovered his daughter's bed was empty. The Spencers called the police, and then he went to find his daughter. As Mr. Spencer drove around looking for his child, he crossed paths with Fosler's truck and saw her in the passenger seat. With Mr. Spencer behind him, Fosler fled with Mr. Spencer's daughter. Yeah, he wouldn't pull over. He would not relinquish Spencer's daughter. He wasn't going to give her back. Mr. Spencer feared not only the repeated assaults on his child, but also that Fosler would eliminate the only witness threatening to secure his life sentence. Yeah, because Fosler could have been going to jail for a really long time, for the rest of his life, because of Spencer's daughter. And Spencer is just supposed to believe that she's safe and sound with this man? No. His daughter was in danger. This man has already put his daughter in danger and done things to her. To prevent further harm to his child, Mr. Spencer forced Fosler's truck to stop. Fosler exited the vehicle and continued to pose an imminent threat to Mr. Spencer and his daughter. Mr. Spencer killed Fosler to protect him and his child. Mr. Spencer later learned that Fosler's vehicle contained a dash camera. The device would have captured the events of that evening, including the routes Fosler traveled before and after taking the minor into custody, as well as his encounter with Mr. Spencer during and after the pursuit. That recording constituted critical evidence for the defense. In July of 2025, defense was informed by Chief Deputy Prosecutor John Huggins that the memory card containing the footage had been lost. So sometime between October 8th and July of 2025, the memory card is gone after being taken into evidence by the Lonoke County Sheriff's Office and cannot be produced. And it says Exhibit A. The Lonoke County Sheriff's Office did not secure the camera in a protective storage container, log the camera and its memory card as separate evidence items, or follow other standard procedures for preservation of physical evidence. Detective McCain allegedly removed the memory card from the camera, viewed the footage, and then sent both the camera and the card to the Attorney General's office. Only the camera arrived. The memory card has, quote unquote, has since come up missing. Defense counsel was further told that the sheriff's office is pretty sure the memory card got knocked out of the camera in transit to the AG's office. No one knows for certain, though. Like, what did you have it in that it would just get knocked out of the camera? Like, what are you doing? Are you throwing it like FedEx throws packages? Like, how does that just happen? Sounds like it wasn't being transported very well, which I'm sure is not in their protocols. Mr. Spencer therefore seeks an adverse inference instruction and an evidentiary hearing under California versus Trombetti and its progeny. Argument: adverse inference jury instruction is necessary. Under Arkansas law, spoliation is defined as intentional destruction or loss of evidence, and when it is established, the fact finder may draw an inference that the evidence destroyed was unfavorable to the party responsible for its spoliation. Goff v. Harold Ives Trucking Co. The Arkansas Supreme Court approved a remedial jury instruction for spoliation in Bun Builders Incorporated versus Womack. AMI 106 correctly and adequately sets forth the law with respect to spoliation of the evidence and the adverse inference to be drawn from it. The instruction reads as follows. So, AMI, effect of intentional destruction of suppression of evidence. If you find a party intentionally destroyed or lost or suppressed description item, so memory card of Fosler's truck for his dash cam, with knowledge that its contents may be material to a pending potential claim, you may draw the inference that the contents of the memory card would have been unfavorable to the parties. When I use the term material, I mean evidence that could be a substantial factor in evaluating the merit of a claim or defense in this case. Arkansas courts have deferred to this instruction in evaluating the applicability of spoliation instruction in a criminal case. And then they cite some cases discussing the applicability of spoliation instruction in a criminal drug distribution case, okay, indicating a criminal defendant would be entitled to a spoliation instruction in that one, adopting civil standard on spoliation instruction in a criminal case. The Ninth Circuit has developed a model criminal jury instruction specifically addressing the government intentionally destroying or preserving the evidence. If you find that the government intentionally destroyed or failed to preserve the memory card that the government knew or should have known would be evidence in this case, you may infer, but are not required to infer, that this evidence was unfavorable to the government. So it basically lets the jury know, hey, there was this memory card. We are not going to be able to show you this memory card or anything that's on it because the state, the government, the prosecutors have lost this evidence. And you can infer or not that this evidence was unfavorable to the prosecution, basically. You don't have to think that. You can say, well, I think that it just accidentally got lost. I don't think that they meant to lose it. Or you can infer that, no, they lost that shit on purpose. Because what was on that? Why did it go missing? Is it because that it shows that the defendant is is not guilty? They're not saying you have to infer that they did this thing, but they're saying you can infer. Here, an adverse inference jury instruction isn't necessary because the government lost a memory card containing video footage of the shooting and the events immediately preceding, despite knowing that the footage was material to Mr. Spencer's defense. Discovery shows that the Lonoke County Sheriff's Office failed to follow its own procedures for documenting and preserving evidence. The dashboard camera was not placed in a protective container, such as an evidence bag, that would have prevented the memory card from being knocked out during transport. The memory card does not appear to have been logged into evidence at any point, even though the LCSO deputy has stated he removed it from the camera and viewed the footage. See footnote 1. Although Lonoke County Sheriff's Office did not inventory the contents of Fosler's truck until July 8th, more than 8 months after his death, its investigators removed the dash cam far earlier, shortly after the October 2024 shooting. Why is it taking you 8 months to log evidence? This is some Karen Reed bullshit. Like, we cannot be doing this. You cannot pay attention to your community. Because if your police station or your sheriff's office is doing this kind of stuff, you need to do something about it. You need to tell them, knock this shit off. Because we do not want people that are guilty of crimes to not get locked away because they are not doing their job. We want to be able to convict the people who are rightfully guilty. We want to protect the community, but if the police are not doing their job, they cannot protect the community. Because this kind of stuff could make it to where lowlifes are out free walking the streets. So we have to make sure that the police department in our areas are doing their jobs. Pay attention to what is going on in your town so that you don't end up looking like dipshits in a public case. Going back up, because of the failures by Lonoke County Sheriff's Office, material evidence no longer exists. The state therefore breached its duty to maintain evidence necessary to ensure basic fairness in the litigation process. The state's suggestion that the device contained no material footage does not withstand scrutiny. To begin, Detective McCain's assertion that all video files on the card were recorded after the incident and just showed blue lights in the background conflicts with the cameras. And we'll continue on that. It doesn't matter what the camera showed. It was your duty to preserve that evidence and hand it over. And now you've lost it, but you're like, well, there wasn't anything on it anyways. Yeah, we would like to confirm that what you're telling us is true. We would like to take you at your word, but y'all have proved that y'all are corrupt. And so excuse us if we don't just take your word for it, state. And if they would have logged it and had a chain of custody and had it put in the proper things, none of this would have happened if they would have followed their standards and procedures and done their job. But they're too lazy. So they go on to say that by them saying that it only recorded the things after and it was just blue lights doesn't line up with the camera's capabilities. Fosler's dash camera was equipped with two lenses, a wide-angle front camera, and a rotatable interior cabin camera, capable of recording both the road and the vehicle's interior and behind the truck. In addition to the blue lights in the background of the exterior recording, there also would have been footage from the opposite direction, including the interior. The interior would have captured the danger Spencer's child faced that night and the trauma she experienced. Similarly, Detective McCain's belief that the dash cam records on a continuous loop so it only shows what was on there until it was unplugged reflects a misunderstanding of how dash cameras function. Turning off the vehicle ordinarily stops the recording. It does not overwrite existing files. There also should have been no need for any files to be overwritten. The camera is marked HD 1080p, and a memory card of the type commonly used in such devices typically stores approximately 16 to 28 or 20 hours of footage at that resolution. Overwriting the relevant video would have required the truck to idle for several hours with the camera actively recording. In addition, most dashcam cameras contain a gravity sensor that detects sudden impacts or collisions such as those that occurred during the events of October 8, 2024. When triggered, the sensor locks the file being recorded, preventing it from being deleted by loop recording. For Detective McCain's statements, as relied by Mr. Huggins in his email, to be true, the interior camera and the gravity sensor both would have needed to fail. The memory card would have needed to be unusually small, and the truck would have needed to idle for hours until the camera recorded enough footage to overwrite all relevant files. Such a convergence of circumstances is unlikely. So, for what this detective is saying, all these things, all these coincidences would have had to happen for what the detective said to be true. A whole lot of shit would have had to be happening for this statement to be true. I mean, could those things have happened? Yeah. But you know what would help figure out if Detective McCain's statements were true or not? The memory card. It's all about proving, not about, oh, he said, she said. No, back up your shit. Court is about having the receipts to prove what you're saying is true. Can't just say because I said so. Ipsy Dixit. That's not how we run trials. Finally, there was no need to remove the memory card at all because the camera had a built-in screen that allowed the videos to be viewed directly on the device. See footnote 2. Removing the memory card without adequate safeguards may itself constitute tampering with physical evidence, a felony. Under Arkansas law, a person commits that offense if he or she alters, destroys, suppresses, removes, or conceals any record, document, or thing with the purpose of impairing its verity, legibility, or availability in an official proceeding or investigation. So, whoever removed this card could have actually committed a felony. Whether they realized it or not, they know you can't be tampering with shit. Stop tinkering with shit that you don't know anything about. If you don't know how to use it, find somebody that does. And if that's what they were doing when they lost the memory card, no, just stop touching shit you don't know anything about. You have state resources, government resources, endless financial means to do things, to prosecute these cases you want to bring. But y'all want to try to do this stuff yourself. No. Send it to the people that can do it. Where you're like, oh no, I could do this. I got one of these in my truck. No. In sum, the Lonoke County Sheriff's Office failure to secure, document, or preserve the memory card and needless removing it from the camera resulted in the loss of material evidence. This reckless mishandling amounts to losing or destroying this evidence intentionally. The lost video footage would have shown how Fosler persuaded the child to leave the safety of her home. Fosler's behavior and manipulation, deception and or threats, and the moments leading to and immediately preceding his death. The information is manifestly relevant to determining whether Spencer's defense was justified. Although some portions of the footage may be partially reconstructed through witness testimony, medical records, and crime scene analysis, these sources are not a complete and fair substitute. The video would have provided a level of objectivity information that cannot be fully replicated through subject recollection or written documentation. Yeah, because seeing it with our own eyes instead of somebody just telling us this is what it is, it's we can believe it more when we can see it with our own eyes instead of just trying to figure out if we can believe what this person is telling us. Because are they credible? Simply put, Spencer has been obstructed from fully presenting his defense. To truly right the wrong the state has inflicted, Spencer is entitled to a curative instruction read to the jury at the conclusion of evidence. If you find the state intentionally lost footage from Fosler's dashcam with the knowledge that it may be material in a potential case against Spencer, you may draw the inference that the dashcam footage would have been favorable to Spencer and unfavorable to the state. When I use the term material, I mean evidence that could substantially factor in evaluating the merit of a claim or defense in this case. The instruction preserves the state's right to produce other relevant evidence and does not preclude Spencer or his daughter from testifying as to their own actions or actions they observed, with the state investigative witness being subject to cross-examination regarding the loss of the dashcam footage. 2. Destruction of evidence warrants a hearing under Brady v. Maryland and California versus Trombetta. So here, Spencer wants to ask for an evidentiary hearing to establish grounds for dismissal. Specifically, Spencer argues that the charges against him should be dismissed as a result of the state's destruction of the evidence in violation of due process clause of the Fifth and 14th Amendment of the United States Constitution, Article 2, Section 8 of Arkansas's Constitution, and principles set forth in Brady v. Maryland and California versus Trombetta. Further developed in Arizona versus Youngblood. The interest of the government in criminal prosecution is not that it shall win a case, but that justice shall be done. In addition, criminal prosecutions must comport with prevailing notions of fundamental fairness, requiring the criminal defendant to be afforded a meaningful opportunity to present a complete defense. What might loosely be called area of constitutionally guaranteed access to evidence. Accordingly, the court requires that the prosecution disclose all evidence favorable to the accused that is material either to guilt or punishment, as well as and then Brady defines exculpatory evidence as evidence favorable to the accused and material either to guilt or punishment. The court held that the suppression of the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith. The duty to disclose such evidence is applicable even though there has been no request by the accused, and encompasses evidence known only to the police. To comply with the Brady, therefore, the individual prosecutor has a duty to learn of any favorable evidence known to others acting on the government's behalf, in this case, including police. Ultimately, the group constitutional privileges delivers exculpatory evidence into the hands of the accused, thereby protecting the innocent from the erroneous conviction and ensuring the integrity of our criminal justice system. So they're saying it doesn't matter if you lost it in good faith or bad faith, like whether you did it on purpose or it was an innocent accident that was just random. But the thing that makes it not good faith is one, you didn't even start by logging it properly. And you also tinkered with it. So already it's looking like bad faith. But if they had followed the protocols and they had logged it into evidence and it was like this person checked it out and we had it in this and this, and then I turned it over to this person and they signed off that they got this and this. But who knows? It could be in somebody's police car, just like that smoking glass pipe that was left in there from a previous thing. Because they're just leaving evidence in cars. Because if you remember in a prior video, we talked about Aaron Spencer getting into the vehicle and was like, that is not mine. Because there was a glass pipe. And the state did say, no, we're not going to try to use that. We know that it wasn't Spencer's. It was there from another case, a previous defendant or an arrestee that was in the car prior to Spencer. That pipe was left over from that scene. So, they're real good with making sure everything's where it should be, right? Good Lord, they need to get their shit together in Lonoke. When as here, the state destroys or loses material exculpatory evidence, evidence that might be expected to play a significant role in the suspect's defense. It violates the Due Process Clause of the Fifth and 14th Amendments and Article 2, Section 8 of Arkansas Constitution. The court addresses the prosecution's duty to preserve evidence on behalf of the criminal defendants. Under the two-pronged Trombetta case test, the government violates a defendant's right to due process when, number one, it destroys evidence whose exculpatory significance is apparent before destruction, and two, the defendant remains unable to obtain comparable evidence by other reasonable available means. The Supreme Court had circuit courts have held that no showing of bad faith is necessary in this instance. So if the state comes back and says, yeah, we lost this, but we didn't do it on purpose, the Supreme Court says, I don't give a fuck. On the other hand, the court in Arizona versus Youngblood developed the principles of Trombetta to clarify that when the evidence is only potentially useful, meaning the exculpatory value of the evidence is unknown, the defendant required to show that the government acted in bad faith in destroying the evidence. So Youngblood says you need to show bad faith. That the necessity of showing bad faith depends on the distinction between material exculpatory evidence and potentially useful evidence. The Eighth Circuit Court followed suit. A due process violation arises from the destruction of evidence when the evidence possesses an exculpatory value that was apparent before the evidence was destroyed, and is of such nature that the defendant would be unable to obtain comparable evidence by other reasonable available means. A higher standard of proof applies, however, when the evidence is only potentially useful to the defendant, unless a criminal defendant can show bad faith on part of the police failure to preserve potentially useful evidence does not constitute a denial of due process rights. The presence or absence of bad faith by police for purposes of the due process clause must necessarily turn on the police's knowledge of exculpatory value of the evidence at the time it was lost or destroyed. Let's see, for example, in Ohio versus Durnwald, the court found bad faith when an officer watched but then failed to preserve the video of a traffic stop and a DUI arrest by accidentally taping over it. The court reasoned the tape may have supported appellant's version of his actions during the stop and is therefore potentially useful. According to show defendant's due process rights were violated, he must demonstrate the trooper's actions amounted to bad faith. Given the obvious evidentiary value of the recording, the court found assertions that overwriting the tape was a mere accident not credible. Since it's likely that the defendant may ask for the videotape and it has obvious evidentiary value and importance to substantiate a trooper's version of the events leading up to an arrest, this court finds it incredible that such accidental erasures continue to occur. Once made, the videotape must be preserved, just as any other evidence regarding an alleged crime or an arrest would be preserved. The court found that such cavalier attitude towards the preservation of DUI videotape evidence rises to the level of bad faith, where ensuring was not product of the machine malfunction, but instead due to the complete and utter failure to safeguard evidence relevant to a crime and arrest, which they did not safeguard evidence in the Spencer case of this memory card. Here, to the destruction of evidence appears to stem from complete failure by the Lonoke County Sheriff's Office to safeguard material evidence related to the death investigation, which is what I just said. They did not safeguard it because they did not preserve it properly. It would be more believable if they had done all the steps in trying to preserve it. But they didn't do that. So the death investigation and the accompanying arrest, the video footage of the moments leading up to the shooting had obvious evidentiary value, and it was highly likely that the defendant charged with second-degree murder would ask for the recording of the encounter to substantiate his defense. And yet, the Lonoke County Sheriff's Office, after reviewing the video and determining its exculpatory value, failed to take even the minimal steps necessary to preserve it, such as securing the camera and its memory card in an evidentiary bag. The office then lost track of the memory card entirely. Such cavalier attitude towards the preservation of the video evidence in a homicide case supports a finding of bad faith. For these reasons, Spencer requests an evidentiary hearing to explore the loss or destruction of the memory card by Lonoke County Sheriff's Office and its failure to preserve this evidence. Spencer expects to show that this reckless mishandling warrants relief, including potential dismissal of charges under California versus Trombetti and its progeny. Conclusion: Mr. Spencer respectfully asks this court to grant his motion for an adverse instruction on spoliation. Mr. Spencer also asks the court for the evidentiary hearing to establish the exculpatory value and their utter failure to follow its own evidence preservation procedures. The failure warrants relief, including potential dismissal of charges against Mr. Spencer, and then that was signed and served to the proper people. I hope that they at least get an instruction in the case. Who knows with this judge? But I hope they at least get an instruction, because if the judge is like, nah, no harm, no foul, and Aaron Spencer, for some reason, does get convicted, then this is going to be a huge argument on the appeal, which sucks that he would have to be convicted and then you have to fight about this issue, because you can't just go put this on stay and go talk to Supreme Court about this. You have to deal with this after he's convicted, which hopefully that doesn't happen, because I think as long as you're not a predator, Aaron Spencer, predator to his daughter, I think you're safe. Like, Aaron Spencer isn't going to come across these same circumstances for this to happen again. Now let's look at the email where all this came to light. So these are the emails. It says, Spencer, a few warrant related questions. Okay. Aaron, I wanted to let you know about the dash cam that was apparently in Fosler's truck that was taken into evidence by LCSO after the incident. Detective McCain took the micro SD card out and reviewed it, the video files on it, but all the files showed to be after the incident and just showed the blue lights in the background and no other inculpatory evidence. He believes the dash cam records on a continuous loop, so it only shows what was on there until it was unplugged. Maybe Detective McCain should have read about the specifics on this camera. And maybe he just clicked and viewed one part of the files, and he didn't view the other files that were on it. Detective McCain sent the dashcam unit along with the SD card to the AG's office for Amber Calmer to do a forensic exam of it. It has since come up missing. Maybe it is lost on Detective McCain's desk. Because I wonder how clean that desk is. Maybe it fell. Maybe it fell into his bag of chips that he was eating at his desk. Who knows? Maybe it didn't get sent with the camera. Could it be in the detective's car? Could it be with Amber Calmer? Could it still be with Detective McCain? It could be anywhere, but they can't seem to find it. Who knows how hard they're actually looking? They have been combing their desks in CID for months trying to find it without any luck. At this point, I'm sure it will be found. I'm not sure it will be found. I will let you know if and when that happens. John. So that was the prosecution sending an email to Aaron Spencer's lawyers. And then it says, no, pretty sure it got knocked out of the camera in transit to the AG's office. No one knows for certain, though. Then why do you think it got knocked out of the camera? So that was Detective McCain that said, no, pretty sure it got knocked out. Then the prosecutor said, oh, yeah, that's right. Sorry, been a bit. Any luck finding the SD card? Detective McCain says, in regards to the dash cam, I talked to Amber and she confirmed that the camera had no internal storage. That's why they want the SD card. Yeah, they don't sound very smart up there. Ugh. Here is the state's response, and they filed this on December 4th. The state of Arkansas, by and through Lonoke County prosecuting attorney, and for response in defendant's motion for adverse inference jury instruction and a hearing on spoliation destruction of evidence states. The defense contends that LCSO acted in bad faith by misplacing an SD card that had been inserted in a dash mounted video camera located in Michael Fosler's truck after he was murdered by Aaron Spencer. The defense offers no evidence whatsoever to support this allegation. Detective McCain personally reviewed the SD card prior to submitting it, along with other electronic devices, to the Arkansas Attorney General's Office for forensic examination. Detective McCain observed multiple video files, all of which depicted nothing more than flashing blue emergency lights from law enforcement vehicles present at the scene. The defense also disregards controlling Arkansas case law and fails to acknowledge that the Arkansas court has never or has ever approved in a criminal jury trial the civil style adverse inference instruction it now seeks. That is true. That is true. Arkansas appellate courts have expressly rejected the use of such instruction in a criminal case, holding them incompatible with constitutional principles governing alleged destruction of evidence and the requirements articulated in Arizona versus Youngblood. Okay, that is true because in a civil case, that can happen. Just like if you plead the fifth, it in a criminal trial, it cannot be used against you if you're the defendant. In a civil trial, pleading the fifth, you can infer negatively on it, but in criminal, you can't. And it might be, because I'm not a lawyer, the same for this. But I think there is a type of instruction that you can tell people about the loss of evidence because there there was a hearing on it and there should have been a hearing on it in Karen Reed, because there was missing stuff there and she never had a hearing. And then even in the Alec Baldwin case, that one ended up getting dismissed because of the evidentiary thing, but there would have been another remedy aside from dismissing it if she wanted to do something else than that. So I don't know if the state is fully correct, or maybe just in Arkansas they've just never used this instruction as far as they're concerned. Um, or maybe just in Lonoke they've never used it that way. But we'll see what the state has, what they also have to say, and then see what the reply to the response is, because the defense will clarify some of the stuff. All right, let's continue on. All right, so here's their brief. Remember, that was the motion. They got to do a brief now. I don't know why they got to file both of these things separately or whatever. It just seems redundant when they could just file this together, like motion and brief. I don't know. All right, so during the homicide investigation of Aaron Spencer, the Lonoke County Sheriff's Office discovered a dash cam that was mounted to Fosler's truck. McCain with the LCSO later found the dash cam contained removable micro SD. Detective McCain removed the micro SD card and personally reviewed the video files contained in. He noted that all files showed a camera angle facing forward with flashing blue and red lights in the background. These flashing and blue red lights were apparently from police cruisers and ambulances parked on the road behind the truck for several hours while the investigation was underway. Detective McCain later returned the micro SD card back into the dash cam and packaged it to be sent to the Attorney General's office along with other electronic devices. Forensics examiner Amber Calmer with Attorney General's office received the dash cam. However, it did not contain a micro SD card. LCSO has made several attempts to locate the SD card, but it has not been found. See Exhibit A, Detective McCain's affidavit. The defense asserts without proof that the LCSO acted in bad faith in and inadvertently losing the micro SD that contained no exculpatory evidence. The defense ignores established Arkansas law that places the burden on the defense of proving bad faith. See footnote 1. The defense motion goes even further, suggesting Detective McCain may have committed the criminal offense of tampering with physical evidence. The claim is woefully unsupported as defense offers no proof that Detective McCain altered, destroyed, suppressed, removed, or concealed the SD card within the meaning of the statute, nor he acted with the requisite criminal intent. The defense argument would lead to an absurd result of creating criminal liability on behalf of any law enforcement officer performing their normal job duties while investigating a crime. Well, you lost the damn card. And maybe you shouldn't have been messing with it. Maybe you should have just let the forensic person deal with it. Argument. An adverse inference jury instruction is inapplicable in this instance. Arkansas courts do not apply civil style spoliation instructions to criminal cases. No Arkansas appellate court has ever approved an adverse inference spoliation instruction in a criminal case. In fact, the court in Autry v. State, the only Arkansas criminal case cited by the defense, denied the defendant's request jury instruction on spoliation, explicitly stating that giving the jury the ability to infer that evidence destroyed was unfavorable to the party responsible for its spoliation is not the law in criminal cases. Furthermore, the model civil spoliation instruction has no counterpart in the Arkansas model criminal instructions. Our Supreme Court affirmed the denial of such instruction because it conflicts with controlling constitutional law. The court found that the proposed instruction in Autry contradicted with Arizona v. Youngblood. In Youngblood, a spoliation instruction was given at the trial level, but it was not adopted as the appropriate remedy by the United States Supreme Court. Instead, the court added the requirement that defendants show bad faith on part of the police to prove a due process violation based on the destruction of potentially useful evidence. Arkansas courts have never followed, or courts have followed Youngblood in their opinions. In Spencer's case, there is no proof of bad faith on part of the Lonoke County Sheriff's Office in an inadvertent loss of an SD card. A bare contention of bad faith without supporting facts does not demonstrate that the state acted in bad faith in destroying evidence. You did not follow proper protocols. You did not log the evidence the way it should have been. You did not conceal the stuff, because if you would have had the camera in an evidence bag or the SD card in an evidence bag or an envelope or a container, if you would have had them together, if the SD card had fallen out of the camera, it would still be in the evidence bag and all of it would still be together. But you did not follow proper procedures and protocols for any of this to happen. That is bad faith. There is no support for the defense's assertion that recklessness, which was not the case here, amounts to intentional destruction of evidence. We don't know that. A bare assertion of bad faith without supporting facts does not demonstrate bad faith. Well, I think that they do have stuff to support it because they showed that you didn't follow your own policies and procedures. The inadvertent loss of the SD card does not amount to a Brady violation. It is a violation of due process, which the state suppresses evidence that is material to guilt or punishment. To establish a due process violation with potential useful evidence is destroyed, the defendant must show the evidence possessed exculpatory value that was evidence before the evidence was destroyed, is of such nature that comparable evidence could not be obtained by other reasonable available means. In addition, unless a criminal defendant can show bad faith on part of the police, failure to preserve potential useful evidence does not constitute a denial of due process of the law. But people have to just take your word, and you're trying to convict this guy. And so the way y'all have run things, it's really hard to just take your word that this is how it was. Because y'all are doing a lot of crazy things in this case. So why couldn't this be another crazy thing? For instance, in Long v. State, the Arkansas Supreme Court held that an inadvertent deletion of body cam footage did not amount to destruction in bad faith. The court held that the defendant failed to show that the body cam video of a search was potentially exculpatory and that it contained evidence that was unobtainable by other means, such as witness testimony. Additionally, because the defendant could not prove bad faith, she did not prevail on appeal. Here, Spencer has failed to show that the video contained on the SD card was potentially exculpatory and that it contained evidence that was unobtainable by other means. Well, the thing is it's not. You can't get some of that stuff by other means. How are you going to find out where Fosler was? Do we have Fosler's text messages to the defendant? Maybe conversations that the defendant and Fosler had? What was the exact time she got in the vehicle? There's a lot of things that we could glean from that footage. The evidence in question is obtainable by witness testimony. Further, there are sworn affidavits from Detective McCain as to what contained on the SD card. The only proof of bad faith is the defense's bare assertion, no, and that you did not follow proper protocols. Conclusion and prayer for relief. For the foregoing reasons, the defendant requests for the above adverse inference jury instruction in a hearing on alleged spoliation should be denied. Arkansas law is clear that adverse inference instructions are not permitted in criminal cases, and defense has offered no evidence beyond unsupported allegations to meet its burden of showing bad faith under Youngblood and its Arkansas progeny. The record establishes the SD's card loss was inadvertent, and its contents were neither exculpatory nor unobtainable by other means. and the comparable evidence is readily available through the witness's testimony. Because the defendant has failed to demonstrate either bad faith or due process violation under Brady, his motion should be denied in its entirety. I don't think the state argued this very well. I think it could be a Brady violation. Now, if there can't be an inadvertent jury instruction in a criminal case like in a civil case, there has to be some other remedy. And it's going to have to be a lower remedy than the case being dismissed because Judge Elmore is not going to do that. So, what is the answer? And is the court going to do anything? Let's continue on with this. It was served to the right people and all that. Okay, now on December 10th, 2025, brief accompanying reply in support of motion for adverse inference jury instruction and hearing on spoliation destruction of the evidence. So this is them replying. Aaron Spencer's lawyers replying to what the state just said, that you can't prove nothing down. So, defendant Aaron Spencer, by and through his attorneys, submits this reply in support of his November 25th, 2025 motion for adverse inference jury instruction and for evidentiary hearing on spoliation of evidence. The motion stems from LCSO, loss of memory card containing dashboard camera recording from Michael Fosler's vehicle. As alleged in the motion, LCSO seized a dash cam that would have recorded critical exculpatory evidence, then failed to secure it. It failed to follow basic evidence handling procedures, unnecessarily removed the SD card, mishandled it, and ultimately lost it. The state's December 3rd, 2025 response and the accompanying affidavit of Detective McCain, which we did not get to see, fail to acknowledge the technical impossibility of McCain's version of events. Yeah, they didn't even touch on that. The state also fails to acknowledge that, unlike in cases cited by the states in its brief, here law enforcement acted contrary to its policies. Yeah, which to me equals bad faith. Because of the factual contradictions at issue here, the court should grant Spencer's request for an evidentiary hearing to further develop the basis for the spoliation sanctions. Like, have butts and seats. Let's talk about this. Following the filing of Spencer's motion, defense counsel tested the dash cam recovered from Fosler's truck and verified the state's version of events is technically implausible. See affidavit of Jason Stashy attached as Exhibit A. The visit further confirmed that Detective McCain did not follow LCSO's policy and acted contrary to his training in handling the SD card in a manner inconsistent with agency practice. Technical testing contradictions. Detective McCain's affidavit. The functioning test of a dash cam contradicts his statements in several material respects. 1. Powering down does not erase files. Testing shows that turning the dash cam off stops recording but does not delete existing footage, contradicting Detective McCain's belief that unplugging the device wipes the card. 2. Dash cam records both front and rear. The dash cam records two streams at the same time, front and rear. Detective McCain's sworn statement that he observed only forward-facing files on the SD card cannot be reconciled with how the device operates. So defense counsel has tested this device, the same device that McCain says he's done these things with. And it sounds like McCain didn't do things right. Dashcam creates multiple directories for front and rear recordings. To store its recordings from front and rear. Detective McCain's claim that he only saw 4 files, all forward facing, is inconsistent with the dash cam's normal operation. 4. The G sensor would have locked the relevant footage. The same impacts that triggered the black box event in Fosler's truck would also have triggered the dash cam's G sensor, locking the recordings from both cameras and preventing them from being overwritten. The state's assertion that the dash cam contained only recordings made after the incident is incompatible with the device's design, which simultaneously records 2 views, stores them in separate directories, locks files during shock events, and retains locked files though even through loss of power. All right, now they're going to another one. Detective McCain violated LCSO policy in his training. As detailed in the attached affidavit, Detective McCain's actions were inconsistent with his training and LCSO policies. Number 1, failure to document evidence before removal. The dash cam was not photographed, measured, sketched, or otherwise documented while still mounted in the truck, contrary to LCSO Policy 16.1. Improper removal causing damage. Detective McCain removed the dash cam with enough force to break its mount, violating the requirement to preserve evidence in its original condition. 3. Failure to separately mark and track evidence. Once Detective McCain removed the SD from the dash cam, he should have photographed it, marked it, and sealed the card in a separate envelope and tracked it through the evidence system. None of these steps were followed. Bad faith right there. 4. Failure to secure evidence containers. Evidence envelopes were sent to the Attorney General's office unsealed and merely clasped, which does not comply with the requirements of proper evidence security or LCSO's policy, especially when containing a small item like an SD card. Not even just an SD card. This was a micro SD card. 5. Violation of agency practice and officer training. LCSO normally sends devices to AG's digital forensics unit with SD cards still installed. Detective McCain himself stated he was taught not to remove SD cards to avoid data loss. Removing the SD card from Fosler's dashcam contradicted both his training and LCSO's practice. More bad faith, in my opinion. 6. Failure to preserve camera settings. The dashcam's internal battery was allowed to drain, resetting the date, time, and wiping critical settings. Policy 16.1 requires preservation of original condition. You done fucked up. Failure to stop or lock the recording at the scene. LCSO personnel, including Detective McCain, allowed the dashcam to continue recording after arriving at the scene. They could have either stopped the recording or used the lock button to preserve existing files. They did neither. And I will say, maybe they didn't know that. Maybe they didn't know when all that was going on. Um, Maybe they should. But I don't know about that number 7. The failures established spoliation beyond mere negligence, unlike in Lee and Autry, where law enforcement followed standard practices. Here, officers acted contrary to policy conducted that supports a finding of bad faith. Right. Because had they have actually followed like all these protocols and then for some reason it's just gone, they may have more of an argument that it really was accidental. It was just so tiny and somehow it just it just happened. Um, but they didn't even do the bare minimum to try to preserve this from the beginning. Conclusion. As the motion, the state's response, this reply, and the accompanying affidavit show that this case presents factual contradictions and technical impossibilities that require resolutions at an evidentiary hearing because the court must make credibility findings regarding Detective McCain and other witnesses. The issue cannot be decided on written submissions alone. Spencer therefore renews his request for an evidentiary hearing to further develop the evidentiary basis for spoliation sanctions. Copies sent to the right people, signed by Aaron Spencer's lawyers. And then basically this is the motion. I think the other one we just went over was the brief, but it basically says the same thing. I'm going to pause it so that if you want to read this, um, you can, but it says the exact same thing. That's why I'm like, this is redundant to file both of these, but it's part of the docket for this particular section of things that we're covering, so I include them. And this is where the attorney signed and certified that it was served properly to the state. Okay, lastly, we have this. We unfortunately do not get to see the affidavit of the person that the defense had look at this camera that contradicts what the detective was saying. Um, hell, I don't even know if the judge is going to allow this person to come testify that they looked at this camera, or if it's just going to have to be done through cross examination. I don't know. Judge seems to be like, yeah, defense, you want witnesses? Yeah, no, you're not allowed to have witnesses. But she did put this order in December 18th of 2025 that states the following exhibits in the above styled case are hereby ordered transferred for storage and safekeeping. Carla Lucas, LCSO, and a photograph has been substituted. Defendant's exhibit number 3, dash cam Fosler's truck. These items may not be disposed of without the court's permission, evidenced by a written order. It is so ordered, signed Judge Elmore. I acknowledge the receipt of physical exhibits described above and further acknowledge my understanding that these items may not be disposed of without further order of the court, and I agree to return these items to the court when so directed. Sergeant Carla Lucas signed it as well, and the receipt shall be filed in the case file with the circuit clerk. So I don't know what any of that means. Um, and we do not have an order saying what is going to happen with this. If we get one and I become aware of it, then I will bring it to you. As I said, this trial is coming up, and Defense Diaries, um, Bob and Ali Mata are going to be boots on the ground for this case because it will not be live streamed. Because, we want to do everything on the DL, hush hush, secrecy. Let's not let people see this. And depending on how long they think this case may go, I don't know if I can get over to Arkansas for like one day. Maybe. We'll see. Because that would be nice. I also don't know how big the courtroom is and how crowded the court is going to be. I may try to find that out before I just go and try to get a seat if there is none available. But thank you for sticking with me on this one. And let me know your thoughts on the case down below. And what do you think? Do you think that the defense is correct and there should be something? Um, do you think this is a Brady violation? Um, or do you think that the state just accidentally did this? You know, they didn't do anything in bad faith. They weren't reckless or negligent or anything like that. It was just something small. But that is it for me. I will see you in the next one. Bye.